Animesh. Welcome to EBC Learning Studio. Friends, today we have got Animesh Sinha with us. He is the owner of the firm Animesh Sinha and Partners. Welcome, Animesh. So, why don't you tell about your journey? How did you got interested in law?
Thank you. Thank you so much for inviting me. Thank you so much to EBC for having me here. Uh, I'm a first generation lawyer, and I didn't really have a set thought process to get into law.
Right.
I was a computer science student, and after my 12th, my father suggested that why don't you take to law, given my background in debating and my interest in history and current affairs. And so I entered law. I did the 5-year LLB honors program, and I'm extremely grateful to my father for having made that decision for me.
Right. So, how was your law school journey? I understand you were involved in many moot courts also.
Law school was very interesting. I think it was a crucible where I learnt many things.
Right.
I spent a lot of my time doing moot courts and debates, and it taught me many hard lessons in life. It did not only teach me how to read the law and apply the law, it also taught me what is teamwork. It also taught me how to deal with disagreeable opinion. It also taught me that disagreeable opinion is not necessarily dissent.
Absolutely.
And that, I believe, today when I look back to what I learned in law school, is one of my essential learnings. The fact that we were different people from different backgrounds, we were trying to learn the law, we were trying to interpret it, understand it. And in that process, what we learned as different opinions comes to have so much use in the practice that we do today. So I look back at law school very fondly, not only for the wonderful moments I had there, but also for the hard lessons I learned.
Right. Why don't you tell something about your moots? You have an impressive portfolio of the moots you did as a law student.
So I did very well in my first internal selections in the law school. But those internal selections were not designed for you to qualify to another round.
Right.
And at that time in my law school, there wasn't this system of national selections where you get a rank and then you choose your moots.
Right.
Also, there weren't so many moots in the calendar anyways. So one of my seniors advised me that, you should not try for moots here and there, just go for the best ones. And that advice stuck with me. So I did 3 of them, which was Commonwealth, Jessops and Manfred.
Right.
And all 3 of them in public international law. And so much that I learned from those 3 moot courts, not only in terms of the volume of research that you're not supposed to do, how do you analyze it, how do you present it, how do you prepare it for oral presentation. And that in many ways made moot courts very close to my heart. And I continued interacting with moot courts much after I graduated by going back for judging of moot courts, by drafting moot court problems.
That's interesting.
And yes, I mean, I'm very grateful for moot courts for who I am today. I think I learned a lot in law school because of that.
Any books you would like to suggest to our?
If you're in law school, I suggest that you must read, not only read a lot of law, but you must read a lot of non-law papers. You must read political science as much as sociology, as much as fiction. Because as lawyers, whether you're going to be dealing with regulatory work or corporate work or litigation work, all of this is modeled on real life. And I think there is something to be said about the earlier system of the 3-year degree first and then the 3-year law course later. People say that they graduated more matured because they had seen 2 degrees and met more people. What happens with the 5-year law course is that right after law school, you are bundled in with 80 kids who have sort of the similar maturity. And when you graduate at 22, 23, I'm sure a lot of kids who are graduating are very bright. But you need to know about life. And therefore, when you're in law school, you must read not only about the law, but also outside of the law. I think when you graduate, the first couple of years, they are very important years. If you don't train yourself to work hard in the first couple of years, I think it's an essential lesson lost. So the first few years essentially you have to train yourself to work hard. And what I mean by that is you must know how much can you read in a day. If in case you can read only 20 to 30 pages in a day, you must be able to maximize that. How much do you retain from what you read? How much do you process from what you do? How do you deal with anxiety? How do you deal with stress? Because these things are inalienable in today's profession. Those first couple of years are very important for you to learn all of this.
And it is really heartening to know that now CJI is very vocal about mental health. Only yesterday he talked about financial difficulties, long hours of work. That is putting a lot of a pressure on the
That
young
is,
girls.
yes, and that
So, I mean, it
conversation
is
must be
good to
had.
see that people are actually acknowledging that there is a problem and mental health is to be taken
Oh,
seriously.
absolutely, and more so in this segment. Not only whether you're working in the regulatory, corporate, or the litigation side, it is a punishing profession time-wise, in terms of how much mental energy it consumes.
Right.
And it is, we are also dealing with a lot of uncertainty and vagaries in terms of how your career is going to get designed and shaped up. And I think maybe it's a romantic thought I have of the earlier years, because I never saw the earlier years. There was a charm to being in the chamber of a senior who was not only somebody whose office you would work in, but whose mentorship you would seek, not only in law but also in life. And I think we are slightly unfortunate that that has become lesser and lesser in today's day and age.
Yeah. You don't get that kind of a mentorship, and that is one issue actually is a challenging to this profession. It's
Absolutely,
a big challenge right now.
and I think that's a responsibility that falls on all kinds of lawyers. Those who are very established, those who are establishing themselves, those who are just a couple of years seniors from law school, for kids who are graduating from your own law school a couple of years back. I think a lot more mentorship is the need of the day.
So you must be having interns and juniors. So what is the quality you look in them when you engage them or hire them?
So I have an opening line to anybody who comes to work with me. I say that, look, this is a profession where mistakes happen. So it's not going to be that you're going through a process where no mistakes are going to happen. And when mistakes happen, it's an uncomfortable experience. So if you're getting into litigation and you don't want that uncomfortable experience, then maybe this is not for you. The second advice I give them is that your work must be of use. My job is to take your work and build on it and not redo your work. This especially goes for the interns that I have. So if you are looking at a proposition and you are unable to find an answer, please come back and tell me you did not find the answer. Or you come back and tell me I didn't get a case law which exactly says that. Rather than you dressing up multiple case laws, making a fancy note and sending it to me, and then I realize that I have to do it again.
Yep. So, redoing is very tedious.
Yes, you're right. It's a very painful process like that.
I mean, your resources are wasted, yours as well as the whoever is working
Absolutely. And there is a issue of loss of trust. Next time you will not trust somebody with an assignment.
So in this course also we'll try to provide placement and internships. So I just wanted to apprise you of
It
that.
is, yes. And it is an excellent system, because once you are looking for interns, at some level you are also looking at the intern as a resource. And if an intern comes to you having knowledge of a particular segment of law, he's not only useful on the assignments, but you start eventually examining whether the particular resource is employable, whether the lawyer can be mentored and trained further. And therefore, I think it's become so easy now with the advent of technology that you can sit in your home and access such rich courses and get access to experience of people who've been in the industry for 10, 15 years. I can't recommend it enough. From the conversation that we were having earlier before we started the interview, I wish I was in law school during these times.
Right.
And I had access to so much of this kind of learning.
This is a very rich resource, the ACL course that we are having right now.
It's very exhaustive.
Very exhaustive.
Very useful.
So did you intern during your law school time?
I did. I did internships. I didn't do as many internships as students are doing now, but I did longer internships. And I had sort of made up my mind that I was going to get into litigation. That made it easier for me to intern.
Right. So where you did your internship? And
So I interned with a law firm which was specializing in insurance law, which eventually has led to a large part of the practice I do today. I interned with a senior advocate, and I interned with one more office of a lawyer who at that stage was just starting to become a busy chamber. And therefore, after my stint in a law firm, I went back to him just to be able to learn how to deal with volumes. So that was my internship in the law schools.
so Animesh, I would just like to know more about the class you are taking with EBC, how you have structured it, I mean, how what do you expect from the students, etc.?
So it's a very conversational class
That's good.
because we are talking of something which has been tickling our bones since the earlier company law, much before the 1956 Act was formulated, as well as it incorporates concepts of what we are trying to incorporate from jurisdictions outside and what we must do ourselves also. So a lot of this conversation will be discussion based, case law based, situation based, and the theme is essentially a conversation on democracy. How are we going to balance the right of the majoritarian shareholder versus the right of people who actually are driving the company in the management? And therefore, it is the pedagogy of the course is very conversational. We will be teaching and discussing the first principles on this issue, as well as examining how the law should react to these different systems and circumstances. So, first, I must say conceptually that when I was in law school, I'm very grateful for whatever training and teaching I learned from there. I am also very conscious of the fact that I was like Eklavya trying to learn a lot of things for which there was no training and teaching during my time. And therefore, once I have graduated, I've been very conscious about it, both as a duty to repay from, for what I've learned from others, I must pass it on, as well as the struggles that I remember being like an Eklavya trying to learn things on my own. So the more and more I can teach and train, I think that becomes useful for people. And I have realized that teaching and training is such a two-way enriching process. I'm sure, people whom we are interacting with learn, but in the reverse, we learn so much from fresh opinion, different angles. Sometimes some questions are so naive, but they are so fundamental to what we are thinking. And maybe 10, 15 years down, when you've been reading that particular subject, you sometimes lose sight of some of those foundational first principles. And that is what I find very exciting about this course by EBC. It's a very comprehensive course, it's very well thought out, it's covering many different angles. And I was very interested in taking the section on shareholder litigation.
Right.
Both for the reasons that it is nascent in many ways, but also because it's foundationally premised on principles of democracy. And the entire conversation about majoritarian view and that there must be some significance to the view of somebody who needs to have merit in the process. And shareholder litigation, this course is very interesting for that reason, that there has to be an equal balancing of rights between the person who sets up the company as well as the majority shareholder.
Right. So the shareholder agreements, it takes you to the core of the corporate litigation. So one has to be actually fundamentally very clear about what they are learning. So I think that is the core of any
That's
corporate
right.
law.
Absolutely. That's very right. And some of the questions that I got while we were doing the earlier module were very interesting questions, and some of which got me thinking. And I realized that this is such an interesting topic for a conversation, and a course like this is best designed for that.
Right, absolutely. I think you are covering class action suits also.
Largely, yes.
Right. So how much of class action suits you have seen in India? Is it?
It is less, and I'm unsure as to which direction it is going to grow, and therefore it is ripe for conversation as to what we are going to do and how the bar is going to take it further, how the society is going to take it
But
further.
don't you think there should be more advocacy regarding the class action? I think people are not aware of the same.
Absolutely.
Because only class action suit that I have heard was against Nestle's for Maggie. Any other, if you are aware of, at least.
So maybe in that ways, we've had some kind of litigation which resembles class action, rather than saying that it's exactly that. And therefore, the conversation is not just what happens with, say, a Nestle case on the Maggie issue, but it can be similar cases. And I think it's an argument of balance. You can't have a majoritarian populist argument to say that class action suit is the need of the hour and we must file it left, right, and center, and people must be held to book through class action alone. I think that is not a fair assessment. A fair assessment is that if you have to bring the management to accountability, there are other systems.
Right.
And class action is going to be one other system like that. And that's the conversation to be had, which I hope to have with the students in the class.
Yeah. Even when we talk about the shareholder agreement and everything, I don't think that level of awareness we have right now in our investors.
Absolutely.
I'm pretty sure about not in the retail investor, but do you think, if you have seen the institutional investors, etc., Do they push their agendas through the company because of...
Not really. You see, it is very company specific like that. Most companies are still very heavily promoter driven in India.
Yeah.
And therefore, shareholders to demand and actually get accountability is something which is a struggle. And therefore, that needs to be achieved. And therefore, if the law exists, it should exist. Whether class action should be used as a tool for accountability, it certainly must be. Is it a panacea of all evils? That is where I'm skeptical. And I think that's where I draw the boundary and the balance there.
So how did you set up your independent practice?
Very difficult to say that. It wasn't by way of design. I started out with a law firm. I worked there for exactly 365 days.
Right.
And because I was a keen mooter, I think at some level I was very impatient to present arguments in court. And largely, the place where I was working was an office for the Supreme Court, so there was no chance. Those are very big matters. I was very happy just to make prints of judgments for the kind of matters that were being done. So thereafter, I went independent just 1 year at the bar, but I was in touch with a couple of chambers from where I was drawing work. And thereafter, I don't think there has been any set process with which I have set up my practice.
Right.
I think a lot of it has been how it has organically come about.
Right. So I was just going to ask you, how do you prepare when you are, as a litigating lawyer, how do you prepare your matters? We know, everybody says that lawyers are having vacations, court. This is something that I'm tired of it now. But we know that we come from court at 4:35, then we take a rest for half an hour or so, then we have a client meeting, then we prepare for the next day. So how do you get time to prepare?
So that's a very interesting question, and that's what makes life of a litigating lawyer very hard. And because we are dealing with a system which is already burdened with pendency, which means that everybody's patience levels are very short. Clients' patience levels are short, judges' patience levels are short. And therefore, lawyers are expected to make very precise arguments.
Right.
A good quality presentation can be made only if you've prepared with diligence. It's not flamboyance, it's not that you have somebody's told you these are the 2-3 top points. You have to look through the brief and know which are the 2-3 important points to argue and why. And that involves a process of eliminating arguments which are not very important. Because sometimes clients will walk in with an image of the case and they'll say, look, this is what my case is. But that's not necessarily the right point to present to court. Therefore, it takes a lot of time to prepare. Preparation does not involve reading. It involves reading and then it involves thinking. And if we as lawyers are unable to take that time out to think, we are then not going to be able to design what our presentation is going to be. That when we are going to go to court tomorrow, what exactly are we going to present? And as you know, courts require different presentations. Supreme Court on a Monday, Friday requires a different presentation. Tribunals require entirely different presentation. Arbitrations where time is fixed and there is a lot more scope for elaborate arguments require different presentation. So the work of a lawyer is very tedious, and work of a lawyer is continuous. It's continuous not only while you are sitting on your chair reading the brief, but it is continuous because you may get thoughts even when you're on your way back home, even when you're playing with your family, playing with your kids, you're taking a shower in the morning. So anybody who is diligent with their process is exhausting a very large majority of their time to this process. And I will not take anything away from other professions. Other professions are also very difficult. But there is an argument in favor to say that, look, lawyers and judges must get some time to reset. And they must get time to build skills.
True.
Because if what we do as lawyers is that we are not practicing just law. When a client comes to us with a different proposition, for example, the course we are doing, if in case the litigation is on shareholder rights, I need to have the time to understand his business, his industry. And if I'm constantly dealing with everyday's firefighting, I never get the time to understand or learn anything else. Which is why there is a strong argument to be made in favor of the breaks that one gets. But I'm sure that's an interesting conversation for another day.
Yeah, but even those breaks, we are perpetually working even during the breaks.
You're right. And in fact, that's a challenge which I have realized now, that one must take out time to reset and build skill.
Yeah.
Because all we are doing is, in many ways, reactionary for the next day's hearing. And that doesn't augur well for us individually as lawyers or the bar overall.
So, what would be your parting advice to the people who want to enter the profession, people who are already into the profession, and if somebody wants to shift from non-litigating side to litigating side?
I think my advice would be very simple, and that would be at it. Uh, Respect the difficulties because there are difficulties and challenges. Relish the opportunities.
Yeah.
You must enjoy the successes when you have it, and you must buckle up when you're not having it because it's a journey. One day you may be feeling on top of the world, the other day you must be feeling right at the bottom of the ocean. It is a journey which goes through phases. When you think you know it all, it is going to turn a curve and take you to a place where you will be lost. And when you will be lost, it will turn a curve and take you to a place where you'll feel better. So my advice would be to be at it and keep yourself busy with whatever you're doing. Positively busy with whatever you're doing.
So, thank you, Animesh, for your time.
Thank you so much for having me here. Such a pleasure having a conversation with you.
Thank you.
you.